All right, I think there's some people still joining in, but I wanted to say welcome and thank you for attending Baker Hostetler's Class Action to Defense 2022 Fall Kickoff webinar. This is a 1 hour and 15-minute presentation. We'll do our best to answer questions that you might have during the course of the webinar, so we encourage you to type them into the chat function. However, if we don't get to your question in time, we'll follow up after the program. So I tried to get Marshmallow and Carrie Underwood to come in here and kick off today's program, but unfortunately, you're stuck with me. I'm Bethany Lukic, and I'm the co-leader of Baker Hostetler's Class Action Defense Team. Our starting lineup today includes a great array of partners and associates throughout the class action team. My co-leader, Julie Singer-Brady, will join me in kicking off the program. She's from our Orlando office, as well as teammates Carl Fanter from Cleveland, Allie Hake from Columbus, Paul Carlscott from Denver, and Kevin Zimmerman from Columbus. I thought Paul today might actually be supporting his home team, but instead he's become a traitor and is wearing a Seahawks jersey, a very bold move after last night's game. We'll be discussing the significant plays in the class action arena during the past 6 months and our predictions for the upcoming season. The program will focus on advertising and consumer product class actions, financial services class actions, insurance class actions, and privacy and data risk class actions. Next slide. So before we begin, I'd like to take a minute to go over a few rules of the game. The program is approved for CLE for 75 minutes in California, Colorado, Florida, Georgia, New Jersey, New York, Texas, and Washington. CLE in Ohio is pending. During the program, we'll share 2 CLE codes. Our first CLE code, coin toss, is up on the screen right now. You'll need to write that down in order to get credit in our post-webinar survey. The post-webinar survey will begin immediately following this presentation, so there's nothing you need to do in order to start it. But if for any reason you have trouble with it, please email Cassie Blaine. Her email address is cblaine, BLAINE, @bakerlaw.com for a PDF of the survey. So without further ado, let's get our terrible towels out and start going. Our first quarter today is going to focus on advertising and consumer product class actions. We're going to be discussing a wide variety of consumer products, everything from food products to antifungal sprays, and class action claims under theories of false advertising, the various state consumer protection laws, common law theories such as fraud, public nuisance, unjust enrichment, breach of express and implied warranties. We're mindful of the play clock, so each of us are going to speed through a bunch of topics today. Next slide. Our first trend that I'm going to talk about is a little preseason focus, injury prevention, and talking about health and safety class actions. We associate benzene, PFAS, and formaldehyde. They're typically chemicals that you associate with personal injury cases and toxic tort. And while that's true, these chemicals are finding their way into the class action space as well. And at least one judge has certified a scary personal injury injunctive relief class. In our last webinar, we reported on the blitz of benzene actions that were making their way into the class action arena. So from the fall of 2021 and continuing throughout this year, 2022, plaintiffs have been targeting aerosol products, sunscreens, deodorant, dry shampoo, and other consumer products and cosmetics. The lawsuits have predominantly followed after voluntary recalls by the manufacturers after testing revealed very, very low levels of unintended benzene. There have been 2 MDL settlements. Only the terms of one of those settlements is publicly available at the moment, and that settlement involves a combination of new testing, vouchers towards future purchases, 2 per household up to 1.75 million, and refunds on recalled products. Those refunds were also available under the recall itself. But at least one court, the District of New Jersey, has thrown out a consumer class action last month brought by a putative nationwide class of purchasers. And in talking about injury prevention, we're going to be talking a lot about standing. And here the court dismissed the court case, saying that plaintiff needed to have more than conjecture to establish an injury in fact. The court also held that the failure of plaintiff to participate in the recall that was available did not affect the standing injury. However, the court found that plaintiff's pleading that the product was worthless was insufficient. The plaintiff hadn't pled that they had to buy replacement product, that they had to throw the product out, or that the product didn't work as intended. The court also found that the potential increased risk that the plaintiff claim didn't sufficiently plead personal injury for purposes of standing and dismissed the case. Next slide. We're going to move on to PFAS. If you haven't heard by now, PFAS is a series of hundreds of chemicals called forever chemicals. Their composition makes them typically long-lasting, waterproof, and stain-resistant. And it's for this very reason that they're found in loads of products: cosmetics, food packaging, personal products, all sorts of consumer products over the years. They're found in our water systems, our recycled goods, and likely all of our blood. PFAS chemicals are a huge focus of the Biden administration. Myself and Matt Thurlow from our environmental department have written several blog posts covering PFAS development in class actions and also the regulatory aspects, and I encourage you to check those out for more information. But again, these chemicals are the target of a lot of consumer class actions in 2022. And these have hit everything from cosmetics to the food industry. Most of the motions to dismiss that are pending have yet to be ruled upon, and so we'll be reporting on those at the end of year webinar. The lawsuits are predominantly for economic damages. In other words, I wouldn't have bought your product if I had known it contained PFAS. You claimed it was quote unquote safe or free from chemicals or natural. Plaintiffs are reviewing manufacturers' on product claims, but also what appears on websites and in your ESG statements, and using those as a basis of claimed misrepresentations and fraud. I want to draw your attention to the first decision on this slide, the Hardwick case out of the Southern District of Ohio, issued in March of this year. And in that decision, the court certified a Rule 23 B2 injunctive relief class. If you practice in the class action space, you know that personal injury classes are almost never certified. Here is an exception. The court held that the certified class constituted all individuals subject to the laws of Ohio who had extremely low levels of PFAS in their bloodstream. In fact, the levels of PFAS in the certification decision are levels at which current technology is unable to detect. The injunction was that defendants were required to fund an independent panel of scientists, epidemiologists, toxicologists, medical doctors, exposure risk assessors, to study and evaluate and then notify the class of the potential effects of these chemicals in the human body. Defendants obviously petitioned for permission to appeal, and their petition was granted last Friday by the Sixth Circuit. The Sixth Circuit was troubled by the class size. Essentially, it was a class of at least the entire state of Ohio, 11.8 million residents, and potentially the whole country. Standing was one of the main focuses, again, of this decision. Of course, the Sixth Circuit hasn't ruled affirmatively on the appeal, but they've previewed much of their concern over the opinion. They questioned whether the remedy would redress the injury, the presence of PFAS in the blood, and whether the court had the authority to order the remedy, an injunction not stopping any specific behavior, but requiring defendants to fund a study at great expense. The court also found traceability suspect. The plaintiff couldn't establish a link between the PFAS in his blood and any one defendant's actions. That was also troubling in the analysis of the commonality question that courts are required to consider. Whether the causation factor could be established in any sort of common way. It wasn't necessarily the common question that was in doubt, but whether or not a common answer could be supplied. And finally, the Sixth Circuit held that 23B2 does have a class cohesion and specificity of injunctive relief requirement. And the court was said that they were skeptical that the Southern District addressed sufficiently those items. So that case will be certainly something that we are watching. I know that there's also a similar case in the New Jersey state courts certifying a personal injury injunctive relief case. So those of us who cross over between products and class actions should be watching those cases very closely. Next slide. Going to quickly run through this. This is a third chemical, formaldehyde. Most of these cases relate to an updated guidance on formaldehyde and hair products that came out last year. Would draw your attention to the Castillo case. Again, we're looking at injury and whether or not there is sufficient injury to have subject matter jurisdiction. And in the Castillo case, at least on the initial complaint, the court held no. Next slide. Our second trend is the green zone. The green zone deals with sustainability and greenwashing class actions. Next. I'm going to start off just with a note about some significant climate change litigation. The Third Circuit in August determined and joined the First, Fourth, Ninth, and 10th Circuit in ruling that state AG environmental nuisance claims should proceed in state court and not federal court. These cases were consolidated and the removal was heavily contested, tons of amici joining in. And so those cases will stay in state court. The other note on these greenwashing claims is that we are now almost more than halfway through 2022, and we're still waiting on an updated version of the FTC's green guides. The FTC recently noted in conjunction with a Wall Street Journal article that they still plan to have these green guides reviewed in 2022, but they have yet to start that process. And it's in this green space that there is still a lot of ambiguity, and you see a lot of actions in class actions dealing with claims relating to natural, undefined in the green guides, sustainable, also undefined in the green guides. So here you have a couple of different cases at various different stages. Most of them, again, in this area, or a lot of these are all over the place and sort of depend on the facts and the specific pleadings. Next slide. This slide points out a whole bunch of cases relating to natural, and like we previewed back in December of last year, the cases again are sort of a toss-up. Some are dismissals, some allow them to go past the pleading stage, and there have been some certifications in this area. Just this morning, there was a very significant decision that came out of the Southern District of New York. In that case, these are the Kind Bar cases. The Judge Buchwald reversed the certification order that had been originally granted in that case, and also granted summary judgment and disqualified the plaintiff's experts. The crux of that decision, however, deals with what a reasonable consumer holds the term all natural means. And the court stated defendant cannot be held liable because it has failed to adjust its labeling to hit the moving target of counsel's various solicited understandings of all natural. Nor can defendant be held responsible for a host of possible, even if potentially reasonable, consumer beliefs about the meaning of all natural. Such multiplicity distorts the reasonable consumer standard. So that language will be very helpful for us who deal with reasonable consumer standards, particularly in the labeling spaces where the claim has not yet been defined. Next. So since I picked on Paul, I'm also going to steal a little bit of his thunder and talk about a new penalty that is potentially developing in our California courts. Next. So the California Invasion of Privacy Act, or CIPA, which is codified in the California Penal Code, makes it unlawful to secretly listen to another's conversation. And unlike other states, in California, the Ninth Circuit has acknowledged in the end of May of this year that the California Penal Code section 631 does apply to internet communications. And as a result of that, we have seen a flurry of new lawsuits. They're predominantly filed against retailers and many, many more that are in the claim arena. And these mainly deal with session replay technology and the chat function on various consumer-facing websites. There are a bunch of different potential defenses that we're looking to see shake out in the courts. Those deal with issues of actual and implied consent based on the various different privacy policies on the website. Whether there are class waivers and arbitration issues associated with these cases that get litigated, and whether or not just participating and having a third-party vendor who is signed up as a service provider is really eavesdropping. And I cite a few cases here that suggest that it's not. And finally, whether or not plaintiffs can get over their fail-safe and overbroad classes as a result of issues of consent to various different communications and understanding of what's going on the website. So with that, I'm going to pass it over to my teammate, Julie Singer-Brady, to continue the conversation.
Good morning or good afternoon, depending on what end zone you're in. Also in the advertising and consumer products class action space, the plaintiff's bar has a new target. Supplements and homeopathic products are taking a hit this season. The new foe seems to be melatonin. There's been a recent filing of a number of class actions against companies that manufacture melatonin, asserting that the bottles are substantially and randomly overdosed, and that consumers are being systematically yet inconsistently misled by labels specifying a specific amount of melatonin per serving when the actual dosage is significantly higher. As a result, the plaintiffs allege that customers are being overcharged and the damages is the entire amount of the product. We're seeing claims brought under state consumer protection statutes, breach of warranties, both express and implied, negligent and intentional misrepresentation, and for unjust enrichment. There have been three recent cases, one in the Northern District of Illinois, and then two in the Northern District of California. This last one impacts my home team, and it's a claim that the Zarbee's gummy melatonins that are largely given to children are putting children at risk because they're being systematically overdosed. We're seeing a new play for alleging entitlement to injunctive relief in response to the normal defense position that a plaintiff doesn't have standing to seek injunctive relief because they're not in fear of imminent harm once they know the alleged fraudulent or deceptive nature of a advertisement or labeling. Plaintiffs are now claiming that the harm is not being able to purchase the products. They want the products and they, quote, need a court order in hand in order to be able to safely purchase the products. Cassie, next slide. Other recent cases that in the last several months is a claim against Walmart for making misleading weight management claims about a dietary supplement and falsely claiming that it's a weight management tool when plaintiff alleges that it is actually nothing more than a placebo. Pharmavite has gotten hit in a number of class actions in the last couple months regarding its Nature Made line, allegations that a chewable vitamin C that is advertised as Mac Extra Strength really has the same dosage of the regular chewables, and also that fruit flavored gummy vitamins, which are represented to be no artificial flavors, actually do contain artificial flavoring ingredients. This is just a smattering of the number of cases that have been filed in this realm in the last several months. Next slide. But flag on the claims, there appears to be good news for the defense. Judges are seeming more and more inclined to rule at the pleading stage that a reasonable consumer would not be deceived instead of simply punting the claim and saying that's a question of fact. There are a number of recent decisions in which a court has granted a motion to dismiss on that basis. Two somewhat recent examples was that Zicam, that the words clinically proven to shorten colds does not imply to the reasonable consumer that there is a scientific consensus about the efficacy. Another recent case, a couple months old, is finding at a Boost chocolate health drinks that no reasonable consumer would be deceived by the representations on the health drinks that they are designed for people with diabetes and that they help manage blood sugar into believing they can actually cure and treat diabetes. In that case, the court actually focused on the targeted audience, not necessarily the broad reasonable consumer, and found that no reasonable consumer of the targeted consumer group would expect a novel diabetes treatment to simply appear on grocery shelves out of the blue. So there the court said that in considering the reasonable consumer, you look at the target audience, and people with diabetes would know better. While obviously getting a motion to dismiss granted is game over, a lesser victory is that courts do seem to be restricting the products at issue and finding that a plaintiff does not have standing to pursue a whole product line on the basis that the products are similarly mislabeled. Instead, the products themselves have to be substantially similar to each other. So in a recent case, the court against Target for a line of beauty products, the court found that the plaintiff didn't have standing to pursue 12 products that they didn't purchase on the basis that they were all advertised as being oil-free. Next slide. A recap is that deceptive pricing claims remain prevalent. These claims have been we're seeing a lot of these claims over the last several years, but they don't seem to be going anywhere. As a brief recap, deceptive pricing is broadly defined as any pricing scheme that is likely to mislead consumers and affect consumers' behavior or decisions about the product or services offered for sale. The FTC guides against deceptive pricing focus on 5 specific types of deceptive pricing: former price comparisons, also referred to as strike-through pricing; retail price comparisons, comparable value comparisons; advertising retail prices which have been established or suggested by manufacturers; bargain offers based upon the purchase of other merchandise; and miscellaneous price comparisons. Of these, the one that's gaining the most yardage is former price comparisons, 50% off, strike-through price tags. Most states prohibit deceptive pricing, or if not specifically, more broadly prohibiting deceptive practices, which would include deceptive pricing and consumer protection statutes. But there is significant variation among the states and the specific prohibitions that advertisers need to be aware of when marketing promotions, sales, and discounts. Next slide. There have been a number of recent settlements in cases that have been pending for several years. Courts seem to be more receptive to coupons, the proverbial coupon settlements then, that now, they used to draw a flag, but now courts are approving settlements where the defendants are not coming out of pocket per se to fund the settlement, but are providing gift cards or vouchers, or a recent settlement against US Polo Association allowed class members to receive 10% off their first purchase of $100 or $5 off any purchase. Most of these settlements also include injunctive relief and require advertisers to have at least disclaimers. In a recent settlement preliminarily approved by the Central District of California, the disclaimer was that the prices are, quote, based on our own opinion of the value of this product, which is not intended to reflect a former price at which this product has sold in the recent past. And then in landing pages and any emails which say that there's a sale or percentage off, there's the disclaimer that discounts may not be based on former prices. Next slide. But these cases continue. In just the last several months, there's been a slew of these cases, including in August, 2 class actions against Walmart and Target for alleging that the shelf pricing is lower than the price that when a customer actually gets to the register, alleging it's a bait and switch. In April, Ashley Furniture was hit with a class action in the Southern District of California regarding its website, that it has fictitious original prices and phantom discounts, and alleging it does this intentionally because it knows consumers are vulnerable to perceived bargains. In April, Dress Barn was hit under similar accusations regarding its e-commerce website. And then in June, the computer company Lenovo was sued in the Southern District of New York over allegations regarding its, quote, policy of fabricating fictitious valuations for its laptop and desktop computers. The complaint alleges that Lenovo, quote, knowingly takes advantage of the complexity of personal computers and the need for consumers to rely on manufacturers' representations regarding the quality and value of different models. These cases are predominantly being filed in California, Illinois, and New York seem to receive more than their fair share of these types of cases under their very strong consumer protection statutes, but they are being filed across the country. There seems to be a new play. There's at least 2 recent class actions, one filed against Warner Brothers and then other developers and operators of mobile application strategy games, specifically the Game of Thrones Conquest and the State of Survival game, regarding the micro transactions that occur during these games, which is the ability while in a mobile app game to make discrete in-app purchases of in-game valuables to level up one's account and to beat their opponents, that these are represented in the heat of a game of being a certain percentage off, or they're 70,000 gold coins for a certain amount of money is put over a strike through of 10,000 gold coins. So the players of the games think they're getting a bargain. The complaints specifically target that the gambling nature and the rapid fire purchase of these. So we will see if those class actions, one was filed in May, one was just filed last week, whether they gain any traction. Next slide. Next, Florida's mini TCPA Act. There is nothing mini about this act, and while this is a Florida statute, its impact cannot be overemphasized because it doesn't just pertain to Florida companies. It impacts any company that makes telephonic sales calls from a location in Florida or from other states or nations to consumers located in Florida. And there is an area code presumption that if the area code of the recipient is a Florida area code, it is a Florida resident. It's called the Mini TCPA Act, but it is much broader. It does not prohibits the use of an automated system for the selection or dialing of telephone numbers without prior express written consent. But automated system is not defined, which has been the subject of defendants asserting that it's unconstitutionally vague, as well as other constitutional challenges. There are severe penalties. The greater of actual damages or statutory damages of $500 per call. And unlike the TCPA, there is an attorney's fees provision and for costs to the prevailing party. Since this statute was amended 15 months ago on July 1st, 2021, on the heels of the US Supreme Court's decision in Facebook versus Dugard, there has been a flurry of class actions, and there have been a flurry of challenges to them too. But recently, two federal district courts in Florida have struck down constitutional challenges to the FTSA at the motion to dismiss stage and declined to interpret it as coextensive with the TCPA. In March, bills in the Florida Senate and House proposing revisions to the FTCA were also sacked, which has emboldened the filing of many more of these actions in recent months. So we will see how these claims play out. No court to date has ruled on the merits of a claim. They're all at the earlier stages. And finally, Cassie, the next and final topic. The 11th Circuit holds the line on prohibiting incentive awards. During our webinar in December, I mentioned that this was a topic of hot debate. And after the 11th Circuit specifically rejected incentive awards, finding them part salary and part bounty. And I queried whether other circuits would file suit. Since the decision in Johnson, at least 12 district courts and other circuits have expressly rejected or declined to follow the 11th Circuit's opinion. And next slide. And just recently, we're hearing en banc was denied in a 7-4 vote. This issue's been around so long that Judge Newsom actually declined to write a concurral because, as he stated, the panel issued its decision in September 2020, almost 2 full years ago. The parties and the bar are entitled to closure. Judge Pryor issued a strong dissent from the denial of rehearing en banc, finding that the majority opinion has broke with decisions from other circuits, and that the stakes are high, and the panel's majority opinion threatens the very viability of class actions in this circuit, referring to the majority's opinion as both grave error and an outlier rule. And with that, Carl, I'll pass it over to you to give a recap on class actions impacting the financial services industry.
Thanks, Julie. I'm a partner in Baker's litigation group, and I also head Baker's financial services industry team. And given the football theme today, I apologize for my gravelly voice sounding like Chris Collinsworth last weekend while he was announcing Sunday Night Football. First, I'm going to discuss a recent Supreme Court case, TransUnion, that impacts many kinds of class actions, including lawsuits against financial services institutions. Second, I'm going to talk about how circuit courts have interpreted TransUnion, including a key 11th Circuit decision from just last week. And finally, I'll provide my thoughts about what 2023 may bring for the financial services class action landscape. So in TransUnion, the Supreme Court narrowed a class action based on violations of the Fair Credit Reporting Act. The plaintiff, Mr. Ramirez, tried to buy a car, and the dealership ran a credit check with TransUnion, which wrongly suggested that Mr. Ramirez was on a terrorist watch list. When Mr. Ramirez later followed up with TransUnion, it sent Mr. Ramirez 2 mailings, once again indicating that his name was a potential match for names on the terrorist watch list. Mr. Ramirez sued TransUnion on behalf of about 8,000 other consumers who also have been identified as potential matches. They prevailed at the jury phase, and the jury awarded the class over $60 million. And the Ninth Circuit reduced the judgment to around $40 million, but ultimately affirmed the verdict. Next slide, please. So by a slim 5-4 vote, the Supreme Court ruled that the 1,800 people whose personal information was actually sent to a third party, like a car dealership, had Article 3 standing. But the 6,000 other people whose information was not actually disclosed did not have standing. The glib sounding, but pretty accurate holding of Justice Kavanaugh's majority decision is no concrete harm, no standing. Although the court did not provide much specific guidance for lower courts, the ruling's a victory for financial services companies defending against statutory consumer protection claims. The Supreme Court took its 2016 Spokio decision and went even further to establish an even higher bar. Specifically, the court made clear that even when Congress has provided a federal cause of action, the mere fact that the law has been violated will not, standing alone, provide a right to sue in federal court. In other words, even if there was no dispute that the defendant TransUnion had violated FCRA, a plaintiff still must show an injury in fact in order to sue in federal court. The majority stated that the 6,000 or so class members whose information was not sent to a third party did not suffer an injury in fact for standing purposes. In other words, inaccurate information of class members never seeing the light of day from TransUnion's file cabinets is not a concrete harm sufficient to sue TransUnion. Justice Thomas, who joined the liberal wing of the court and wrote one of the two dissents, argued that the majority opinion improperly added an independent injury in fact requirement to sue in federal court. Next slide, please. So what are some key takeaways from TransUnion? First, the Supreme Court was unambiguous that each claim and each form of relief requires separate standing to sue. In other words, just because a plaintiff has standing for injunctive relief, that doesn't mean that she has standing for a damages claim, even for the same cause of action. Moreover, each class member must have standing. The decision widens the door for standing-based challenges to class actions on a going forward basis. For example, the court held that while the named plaintiff had standing for all 3 FCRA claims, the rest of the class lacked standing for 2 of those claims. Second, proving injury in fact or concrete injury for statutory claims will require comparing the alleged harms covered by the statute to existing common law claims. For example, in TransUnion, the court compared the FCRA violations of the 6,000 folks to an unpublished defamatory letter and observed that a plaintiff could not sue for an unpublished defamatory letter under common law. Third, under TransUnion, will the risk of future harm may be sufficient to have standing for injunctive relief? That harm may not be sufficient for a damages claim. Next slide, please. So how have circuit courts interpreted TransUnion? Well, just last Friday, the 11th Circuit issued a decision en banc in Hunstein. There, in a lengthy decision, the 11th Circuit issued a decision en banc, 8-4, where basically the court held that there was no standing for a violation of the Fair Debt Collection Practices Act. The decision, again, like TransUnion, is a victory for the defense bar. Following TransUnion, the court had rejected Hunstein's claim that has suffered harm, which was when the defendant debt collector sent information about a medical debt to a third-party vendor, was similar to the common law tort of public disclosure of private facts. The court stated that even if the letter vendor's employees saw Hunstein's information, disclosing information to private individuals is not the same as publicly disclosing facts. The court characterized Hunstein's allegation as a bare procedural violation. Interestingly, the court did not analyze whether sending the data to the third-party vendor actually violates the FDCPA itself. That being said, the court did observe that it did not think Congress intended the FDCPA to apply to data sent to third-party vendors. It's unclear whether the plaintiff will try to appeal to the Supreme Court or try to amend their complaint with additional allegations regarding injury, or try to bring the claims in state court that may not have analogous Article 3 type standing requirement like that articulated in TransUnion. Judge Newsom, who Julie just mentioned, who wrote the 11th panel decision originally, dissented. He argued that Hunstein's intensely private information was disclosed to strangers and suggested that the majority was whitewashing the complaint's allegations of harm and contended that a circuit split existed on these standing issues. Next slide, please. which in fairness to Judge Newsom is not an unreasonable position. The 10th Circuit in Lupia found that the plaintiff debtor had standing for her two FDCPA claims. The plaintiff debtor alleged that she had suffered intangible harms, not physical or monetary harms. The plaintiff had received a voicemail from a debt collector on the day after the debt collector had received a cease and desist letter. Lupia, like Hunstein, also involved in medical debt. But despite the fact that the defendant only made one call to the plaintiff, and she didn't even answer that call, that court found a concrete harm under TransUnion because the FDCPA claim was similar to the common law tort of intrusion upon seclusion. The dissent in Hunstein, unsurprisingly, cited Lupia favorably. Now, on the other side of things, just last month, the Fifth Circuit in Perez held that simply sending a letter to collect a time-barred debt, even if that would violate the FDCPA, is insufficient to show an Article 3 injury. In fact, even though the defendants didn't raise the standing issue because it was on appeal via a 23F motion, the panel addressed it sua sponte because standing is jurisdictional. Next slide, please. And right before Labor Day, the Third Circuit applied TransUnion again in the data breach context this time, and found that a plaintiff can sue for his imminent risk of identity theft, so long as the plaintiff also points to currently felt concrete harms. Now in Clemens, the court stated that the concrete injury may simply be emotional distress based on knowledge, of the data breach and their data being published on the dark web, or spending money on things like credit monitoring services. But in Maddox, the second court dismissed a lawsuit based on lack of standing under TransUnion. There, that lawsuit was based on a state statute giving a private right of action for a bank failing to record a mortgage satisfaction in a timely fashion with a county recorder, and provided for statutory damages. Lots of these class actions have been filed against banks throughout the country for decades because, for a variety of reasons, it's difficult to get the paperwork turned into the recorder on time. Like the class members in TransUnion who had a FICRA claim, but their information never actually went to third parties, the Maddox court observed that the plaintiff did not have a claim because even if the misleading record existed in the public file, there was no evidence that that record, or I suppose the lack of record, was ever read by anyone. Thus, the court reasoned there was no concrete harm for Article 3 standing. So stepping back for a minute, what do all these cases mean? First, they show the significant impact that TransUnion has had over the last 12 months. And two, how closely courts are now scrutinizing plaintiff standing for statutory violations, many of which apply to financial services institutions, as well as the importance of plaintiffs showing concrete harm to proceed on a class action. Three, I suppose, the reality is that despite the different approaches of courts, challenging Article 3 standing is a better tool for class actions for defendants than it was in 2021. Next slide, please. Moving on from standing issues, the Ninth Circuit reversed the dismissal of a state law breach of fiduciary duty class against Edward Jones, holding that the Securities Litigation Uniform Standards Act did not bar such a claim. The court, however, construed the act narrowly, stating that the act only bars actions based on alleged misrepresentations that would violate federal securities laws in connection with a plaintiff's decision to buy or sell securities. But because the plaintiff's complaint there alleged that the omissions only related to their brokerage account fees, the act didn't bar the plaintiff's claims. Edward Jones sought cert in the Supreme Court. The U.S. Chamber of Commerce and other amici lined up in favor of taking cert. But despite the arguable circuit split, the Supreme Court denied cert earlier this year. Next slide, please. Finally, it would not surprise me to see an increase in consumer banking fee-related class actions in 2023. There's been a renewed focus on these fees by consumer agencies, and there's often an increase in consumer class actions in areas of emphasis for exams and enforcement by government agencies. For example, earlier this summer, the CFPB announced that it's gathering information on banks' overdraft and non-sufficient fund practices, and considering issuing guidance on what practices would be improper. This is part of a broader shift to a more aggressive CFPB since the change in administration. the CFPB also intends to significantly increase the amount of guidance that it provides generally to the marketplace. So to that end, earlier this summer, the CFPB also issued an advisory opinion regarding the permissible purposes for which credit reports may be requested under the Fair Credit Reporting Act, FCRA. So in addition to seeing increased enforcement actions, I expect to see an increase in class actions against financial institutions regarding these consumer fee and reporting issues over the next 12 to 18 months. Thanks to all of you for your time. I'm going to pass it now to Allie and Kevin to discuss recent trends for insurance class actions. Allie and Kevin.
Thanks, Carl. My name is Ali Hawk. I'm based here in Columbus, Ohio, with a litigation practice with a particular focus in the insurance industry, and especially insurance class action. So that's what we're going to talk about here today. I'm going to pass it off to my colleague here, Kevin, who's going to get us started.
Thanks, Ali. Next slide here, Cassie. So we're going to begin in the realm of automobile insurance, which continues to see development in two different strands of class actions relating to total loss insurance claims for totaled automobiles. The first is tax, title, and fee cases, which allege that an insurer fails to pay certain items allegedly required to purchase a replacement vehicle, things like sales tax, dealer's fees, etc. The other strand, which we'll talk about today, is total loss valuation cases. And these allege that an insurer or a third-party vendor improperly calculates the value of a totaled automobile after an accident. Last time we gave this presentation in January, we discussed competing injury analyses in the tax, title, and fee cases. And in the first half of 2022, we saw that same analysis in two competing total loss valuation cases. Lewis here from the District of New Jersey and Laura from the Ninth Circuit. In many of these total loss valuation cases, insurers can present evidence that some insureds were paid more than the plaintiff says they were required to be paid. And so the key issue is whether this raises individualized liability questions or just questions about how to calculate damages for class members. As the competing Lewis and Lara opinions show, appropriately framing the issue as a liability question or as a standing question under TransUnion, as Carl discussed, can make all the difference. Note that this issue can arise outside of the insurance realm too. Anytime there's evidence that certain class members were not harmed by the allegedly unlawful conduct, you should think to frame the issue as individualized liability inquiries, not just individualized damages questions. Next slide, please. Another opinion from the total loss realm out of the Fifth Circuit reminds us that Rule 23A4's adequacy requirement can still have significant bite. It's similar to the predominance issue discussed in the last slide. What if some class members are better off with defendant's way of doing things as opposed to how plaintiff says it should be done? That raises so-called intra-class conflicts that can defeat adequacy under Rule 23A4. Now, in Prud'homme, the court held that adequacy was not satisfied because a portion of the class benefited from the allegedly unlawful conduct. Prud'homme's analysis looked backwards into whether class members would or would not have been better off, whether they would have been paid more had plaintiff theory been applied. But when thinking about these issues, you don't need to limit yourself to just backward-looking so-called retrospective interclass conflicts. Plaintiff's liability theory might make some class members worse off in the future, and that can raise prospective conflicts too. And in fact, that could be a potentially stronger argument because it demands that the court forecast the future somehow to see who would or would not benefit from plaintiff's theory for purpose of an interclass conflict argument. Next slide, Cassie. Another lesson in the total loss cases is not to forget about the merits in a class action. And this comes from our own team here in Columbus, where we secured the first full summary judgment for an insurer on breach of contract, bad faith, and statutory claims in a total loss valuation case. The broader coaching tip here, or practice point, is to think strategically about how and when to present the merits and class certification issues together in a case. The so-called rule against one-way intervention is a rule that typically prohibits plaintiffs from moving for summary judgment before class certification, but it doesn't prohibit defendants from doing so. Sometimes class action defendants shy away from moving for summary judgment because the ruling only has res judicata implications against the individual defendant, not the broader class. But if you're able to set good precedent on a motion for summary judgment, it can be used as an equally effective shield against future potential claims. And depending on your arguments, summary judgment briefing can also set the stage for the class certification arguments you're going to make. For example, in this case, the insurer alleged that plaintiff had not introduced specific evidence that she had been paid less than her own vehicle was worth. If the plaintiff's response to that question requires her to point to plaintiff-specific evidence, that's a good way to highlight the individualized inquiries that would be required to prove liability for each and every other class member. Those inquiries might also depend on class member specific evidence. Next slide here.
Thanks, Kevin. Moving next to an issue arising from the labor depreciation and COVID business interruption class action space. And if you're not in the insurance world, you're probably wondering what I'm talking about. So some very brief context. The labor depreciation cases are about how insurers calculate indemnification for property damage insurance claims. COVID BI cases, business interruption cases, are about whether an insured's loss of business income from COVID or the pandemic should be paid out under commercial property insurance policies. But the issue that I want to discuss impacts really any industry where you have both federal and state appellate courts chiming in on the same issues of state law. In these labor depreciation and BI cases, we have more and more federal and state intermediate appellate courts deciding essentially the same issues of state law. And we're starting to see instances where state intermediate courts disagree with those federal circuit courts. So that raises a question as to what a federal district court is supposed to do when there is that kind of split. We know that ordinarily circuit courts bind their district courts. Well, should a district court follow an intermediate state court over a federal circuit court on an issue of state law? Now, my gut initially was, of course not. Follow your circuit court unless the state Supreme Court has ruled, but not so fast. So, Cassie, could you go to the next slide, please? Again, this issue has arisen both in the labor depreciation and the COVID business interruption context, where federal circuit courts have sided with insurers on an interpretation of state law, but some subsequent intermediate state courts have sided with insureds. And we've highlighted a couple of instances of that. You'll see in the labor depreciation space, we had the 8th Circuit find that labor depreciation was permissible under Missouri law, while the intermediate state appellate court found that labor depreciation was not permissible under Missouri law. In the COVID BI space, the cases that we highlighted here, the 5th Circuit found that there was essentially no coverage under the commercial property policy at issue, while the state intermediate appellate court found that there was coverage. And so that raises, the issue of whether there should be a different analysis in circuit versus out of circuit as well. Cassie, could you go to the next slide, please? One thing to consider here is there was a case out of the 5th Circuit, the Alter and Sons Access Surplus case, and the oral argument in that case covered exactly this precise issue. And with some of the judges showing skepticism about whether an intermediate appellate court could overturn essentially a prior 5th Circuit panel view of Louisiana law. There are two interesting notes about that particular case. First is the added wrinkle of Louisiana, which is a civil law jurisdiction. And in civil law jurisdictions, state courts really aren't supposed to create new law in the first place, so they shouldn't be able to change it either. At oral argument, one of the judges remarked, and I quote, "I went to law school in Louisiana, and intermediate state appellate courts in Louisiana don't make the law in Louisiana. Not even as a matter of fact, one decision of the Louisiana Supreme Court makes the law." The second nuance there, and this is a bit unique to the insurance class action space, is whether a case ends up in federal or state court can depend on the unique makeup of some of the insurance entities at play. So there was one case that we pointed to in an earlier slide where the case was probably only heard in state court because of the unique structure of the carrier. These kind of jurisdictional nuances pop up pretty frequently in the insurance space because of the structures that certain insurance entities take. So for example, mutual insurers citizenship can depend on the state law classifications of the mutual insurance company. And some insurance companies are organized as inter-insurance exchanges, and the citizenship depends upon which states have exchange members. So these non-typical diversity situations make it very important to understand the CAFA removal requirements essential to the early stages of an insurance class action. Cassie, can we go to the next slide, please?
So another development we discussed last time in the labor depreciation space was the increasing proliferation of multi-state class actions against insurers. And we discussed some of the predominance arguments to consider in those cases at the class certification stage. But a recent opinion in the labor depreciation space provides another good reminder that can be earlier challenges to class certification too, at the pleading stage. And it also highlights a growing trend of arguments for early challenges, attacking multi-state claims for lack of standing. Next slide, please. Now, the traditional means of challenging class certification in a motion to strike is arguing that no matter what's discerned in discovery, a class can't be certified. These arguments have had some success, particularly for multi-state class actions, but more often than not, the courts say that's an issue we should defer to the class certification stage. But Brown here shows a different type of argument. It's an otherwise typical labor depreciation class action with claims from multiple states. And rather than arguing that predominance could never be satisfied, the insurer argued that plaintiff lacked standing to assert claims under the laws of states besides his own. The court agreed, holding that plaintiff had no injury under any other state's law. And this kind of standing argument is potentially powerful because it preempts the let's wait for the class certification stage response. If a plaintiff doesn't have standing to bring claims under any other state's laws, nothing in discovery should be able to change that. Now, I'll pause for a moment to worth noting that you want to be careful what you wish for here too, because plaintiffs' lawyers can often find new plaintiffs from a new jurisdiction to bring a new case. So there can be trade-off between the benefits of limiting the class to one state, particularly if it's an unfavorable form, and the cost of litigating multiple different cases in multiple different states. Next slide, please, Cassie.
So we're going to talk about claims made settlements through the lens of tax and fee class actions, which Kevin briefly mentioned earlier. A claims made settlement, as we know, is settlement where class members have to submit claims to obtain a payout from the class settlement. With a claims made structure, there's typically a more complete recovery for any class member who submits a claim. But since not all class members will actually submit a claim, this can sometimes result in a discount off the total liability. Typically, claims made settlements do not affect plaintiffs' counsel settlement incentives because their fees are based off of the total possible recovery, not the actual take rate. There is a recent Washington state tax and fee case that we've highlighted here that talks about this issue, and it did question that premise, though, holding that class counsel's fees should be based on the actual class recovery through submitted claims rather than the maximum possible recovery. Now, this initially sounds like a good thing for defendants because it's lower attorney's fees, but could actually be bad for defendants in the long term because it could curb plaintiffs' counsel's incentives to agree to a claims made settlement structure in the first place. Usually the extra fees are often worth it for the claims made discount. Can we go to the next slide, please? Now, I don't think this will gain much traction because this may be limited a bit to the circumstances of the case and to the jurisdiction. First, it was a particularly stark contrast between the attorney's fees and the class recovery in this particular case. The attorney's fees were over 160% more than the total payments to the class members through the claims made process. Second, the case did rely heavily on prior Ninth Circuit case law. So there's an argument that this is unique to those jurisdictions, if not even unique to this particular court. Next slide, please.
So we're cutting close on time here, so I'm just going to spend maybe 30 seconds on the worlds of life insurance, where so-called cost of insurance class actions have been racking the industry in recent years. These are cases that have generated massive settlements against life insurers for the interpretation of flexible premium life insurance policies. Next slide, please. The update here is just that this year there have been 6 different classes certified in these cases against various life insurers across the countries. And despite various insurer arguments about interclass conflicts, lack of Comcast fit for damages, the courts by and large honed in on the fact that these are cases about form contracts, and thus said that was enough for certification under Rule 23. And I'll hand it off back to Ali to conclude here.
Thanks, Kevin. And this last topic really impacts all class actions, but I'm going to discuss it here. We just wanted to highlight what has happened with recent appointments in the last two presidential terms. President Biden has actually appointed 80 new federal judges as of yesterday, and President Trump had nominated 226. For context, in one term, President Trump appointed 54 circuit judges, while in two terms, President Obama had appointed 55. So far, President Biden has appointed 21 circuit judges. So why does this matter? Now, political ideology is never a perfect predictor of judicial results, but we've identified this one law review article that did an empirical study on this. And it found that all Democratic appointed panels have dramatically higher rates of pro-certification outcomes than all Republican appointed panels, nearly triple in about the past 20 years. Now, it remains to be seen what impact President Biden's new judicial nominees will have on the state of class certification law, particularly against the backdrop of a now very strongly conservative Supreme Court. But this is definitely something to keep in mind and keep an eye out for. And I'm going to now hand it off to Paul to continue the presentation.
Well, hello, everyone. As Bethany noted, I'm a partner in our Denver office, but I didn't lose a bet. I'm actually a very longstanding Seahawks fan. And so in the spirit of our football-themed presentation, I have proudly worn my Seahawks jersey to the event. They're now in first place, so I'm very, very happy about that. That won't last. So I'm going to be talking today about some trends in privacy and digital risk class actions. And if Cassie, if you'd move to the next slide, please. I've really broken it down into two key areas. One is data breach class actions. So, excuse me, class actions that arise after there's been a data breach and individuals have been notified that their data has been impacted. And then the second group of class actions I'll be talking about briefly is privacy class actions. So those would be class actions that don't relate to a data breach, but rather arise out of defendants' alleged misuse of information or wrongful collection or disclosure of information to third parties. So if we move to the next slide. So some of the trends in data breach class actions, first of all, I'll talk a little bit about what industries are being affected. And I think a lot of this has more to do with the criminal activity that creates the data breaches in the first place than it does the activity in the plaintiff's bar. The plaintiff's bar seems to go where the data breaches occur, and these days, healthcare is really the top industry that's been impacted by data breaches over the last several years. Healthcare data breaches are very predominant. There are a lot of cyber attacks involving ransomware and phishing. Those right now tend to be the most common types of data breach events that we're seeing. And therefore, the class actions that are arising tend to involve ransomware or phishing attacks on healthcare entities. There is a growing number of industry activity in the financial services, particularly those companies that deal in cryptocurrency. So that seems to be a growing target of cyber attacks, and we're seeing more data breach class actions being filed in that industry now. Years ago, really the top target tended to be retail, and that was payment card systems, credit cards and debit cards. We're seeing a lot less of those these days. And I think that's in part due to changes in the technology in how payment cards are processed and handled, and protections on payment card systems. Healthcare, I think, is targeted most mainly because it's Healthcare entities tend to be focused on what they do well, which is provide healthcare for people. That, combined with the fact that changes in the law over the last decade really increased the amount of data that healthcare providers are required and encouraged to have available to their patients. And so I think those combination of factors has really created what we're seeing in the trends. Other trends generally that we're seeing in data breach class action litigation, one big one is, and this is something that kind of goes up and down depending on the year. Certain years, it seems like courts are dismissing data breach class actions, and other years, it seems like they're surviving more and more motions to dismiss. Lately, we've been seeing more cases that are surviving motions to dismiss. The plaintiff's bar has become very, very good at finding a variety of creative theories and arguments that they can insert into their complaints, and also more and more are able to find individuals who claim some form of identity theft or misuse of their information after the data breach event. Now, that doesn't necessarily mean that the identity theft that's being claimed has a causal connection to the data breach that gives rise to the lawsuit, but at the pleading stage, most judges are not willing to consider arguments that are based on causation. And for that reason, while we were seeing 8 or 10 years ago, many cases involving data breaches being dismissed for lack of standing because the plaintiffs couldn't articulate an injury, we're seeing more cases survive because, one, the plaintiffs that are bringing the cases are claiming some form of fraud or misuse. And secondly, the plaintiff's bar has become much more creative in terms of the types of damages and theories of injury that they're bringing in these cases. And a good example that we're seeing recently is courts buying into what the plaintiff's bar refers to as the benefit of the bargain theory. This is a theory where an individual who, and I'll use healthcare as an example, a patient, say at a hospital, claims that there was some contract for the protection of the plaintiff's data, and because the hospital didn't protect the data, that the hospital breached the contract, and the plaintiff should get some damages as a result of the loss of the benefit of the bargain. There's a surprisingly little case law that really addresses this question of whether you simply should be entitled to some arbitrary amount of damages because you didn't have your data protected. And I think at the early stages, a lot of judges, especially at the state court level, don't give a lot of thought to what that really means. You know, that the idea that someone paid money for data security is something that I think doesn't happen in reality, but from a theoretical point of view, a lot of judges will buy into that argument. And so that's an argument that we're seeing more and more cases survive on. Again, as I said, this goes in cycles. And so some years I'll report that more cases are being dismissed at the motion to dismiss stage, particularly because in most cases, it's very difficult for someone to show that they've been actually injured in a financial sense after a data breach. And I think, as everyone knows, we're seeing more and more every year, we're seeing more and more notices, and everyone gets them, that your information's been affected in a data breach. And very few of those ultimately result in mass identity theft. And so, but nonetheless, data breach cases are still thriving. They're being filed en masse, and I don't see that stopping anytime in the near future, unless we see some legislative change, which is unlikely. On the class certification front, there have been a couple of decisions in the past year where lower courts have certified classes of data breach litigants. And I've cited a couple of them in the slide here. Brinker in the 11th Circuit is a payment card case where the lower court certified case as a class action, and then the Marriott case in the 4th Circuit. Both of those cases are on appeal, and the appellate courts have accepted interlocutory appeal in both cases, and we're waiting rulings in those cases. So it remains to be seen what will happen in either or both of those cases. But so far, those are sort of a change in the existing trend, which was most cases that got to the class certification stage were not being certified. And the primary reason they weren't being certified was the fact that the injury issues, whether individual people were injured as a result of the data breach, is a purely individualized question. And that has tended to be the kind of the stopgap for defendants in defeating class certification in data breach cases. So we'll see what the 11th Circuit and the 4th Circuit have to say. Hopefully I'll be able to report on one or both of those decisions the next time we give this presentation. Settlements. In the last presentation, Ali talked a little bit about claims made settlements and why they can be beneficial to defendants. We have had great success in getting early claims made settlements agreed to and then approved by courts in the data breach context. In the data breach context, there's, I think, some unique features that allow claims made settlements even for skeptical judges. And it really has to do with the fact that there may be people that have suffered some form of loss or inconvenience as a result of the data breach, but you don't know who they are. And so a claims made settlement allows the parties to create a claims program where affected individuals can provide some minimal form of proof of out-of-pocket loss. Typically will also allow for the recovery of modest amounts of money for lost time. So say $15 to $25 an hour for up to 3 hours of lost time associated with the inconvenience of having been notified of a data breach. And so those types of settlements have been very successful. They can be done in a way where the settlement costs less than the cost to win the case from a defense perspective. And I think that's one of the reasons we're seeing so many settlements in the data breach context. Next slide. So very briefly in the time we have remaining, I'm going to talk a little bit about some trends in privacy class actions. And the big one right now that we're seeing is class actions that are brought against mainly hospital systems that allege that privacy rights have been violated because those hospital systems use the Facebook Pixel tool on their public-facing websites. Lately, there have been some additional cases that at least allege that in addition to using the Facebook Pixel on public websites, they're also using Facebook Pixel on patient portals and websites that involve actual communications with patients. It remains to be seen whether those allegations are factually true or not, but we're seeing more cases making that allegation. But this trend really arose out of the argument that using Facebook Pixel, which is a tool used for targeted marketing, causes users' browsing activity to be sent to Facebook. In most cases, there's no disclaimer or notice on the hospital's privacy policy that indicates that Facebook Pixel is being used. And so the argument is that what I'm browsing and what I'm looking at on a hospital's website is being sent to Facebook, and that violates my rights either under some sort of a common law privacy theory, or in many cases, they're bringing causes of action under state wiretapping laws. That is also a trend we're seeing more generally. Bethany, in her presentation, talked a little bit about the growing trend that we're seeing in California with wiretapping claims based on the use of session replay technology or chatbots, both of which tend to be focused on retail sites. And then recently, there have been some unfavorable rulings in both the 9th Circuit in California and the 3rd Circuit involving Pennsylvania law that very, very broadly interpret state wiretapping laws that would cover a whole host of common technologies that are used on internet sites. And so it remains to be seen whether those trends will continue. But right now we're seeing a big trend in California, and I expect to see a growing trend of wiretapping claims being brought in Pennsylvania as a result of rulings there. There were also some cases involving the use of technologies in vehicles, automobiles that also were brought under wiretapping laws in the state of Washington. Those cases were unsuccessful, but are now on appeal. So there are some other trends that I will leave to your reading. I think we're at the end of our presentation time, so I'm going to turn it back over to Julie to wrap things up for us.
Thanks, Paul. Yes, the clock has run out, and so as co-leader of Baker Hostetler's Class Action Defense Team, I want to thank you for attending today's webinar. You will see the second CLE code up on the screen. Please feel free to email us if you have any questions, and we'll do our best to respond. We hope you will join us again at the close of the year for our annual Class Action Year in Review webinar. For those of you who would like CLE credit, please stick around for the post-webinar survey when we will ask for your bar number and both this code and the code you saw earlier in the presentation. Should you have any questions regarding CLE, please email cblaine, that's CBLAINE @bakerlaw.com. Thank you for attending. See you in December.